Okay, welcome back, everybody. We're going to take a look at some of the different types of evidence you might see in a criminal trial. So, this is largely definitions of the words that you'll hear associated with evidence. Let's take a look. First of all, relevant evidence. Evidence that you bring into court has to be relevant to the case, meaning it has to prove or disprove something that's going on, and that something has to be disputed, meaning one side says it happened, the other side says it didn't happen. Types of evidence that it might be used for this: physical evidence, forensic evidence, testimony. We'll talk about those. Exceptions. The exclusionary rule, I mentioned this earlier, but evidence that was illegally obtained, it cannot be introduced in court. There's something called hearsay. This is something that somebody heard outside of the court. The person who actually heard or saw the subject of the testimony, that person has to be brought in, sworn in, and they have to testify directly to what they saw. Another person cannot testify on someone else's behalf. Privileged communications, we also talked about that last week, but that's attorney-client privilege and some other exceptions that are similar. So what is relevant evidence? I'll read you the definition. Evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action, which is the case, more probable or less probable than it would be without the evidence. So let's take a look at some related terms that we will define in a moment. Relevant evidence, we just defined that. At issue, material evidence, probative value. We'll take a look at these terms and see what they mean. So again, what is relevant evidence? It tends to prove or disprove something that's in dispute in the case. The key to determining what is relevant is the question of what is at issue. And that means what is being discussed, what is being disputed. No evidence can be admitted to prove facts that are simply not at issue. Nobody's talking about them. You can't bring in evidence about things that aren't relevant to the case. So at issue, that refers to all the disputed facts that are needed to establish the elements of the crime. Remember, the DA has to do that. They are the facts that are being presented, asserted, or disputed in the case by one side or the other. Those are the items that are at issue. Relevant evidence must also be material. In other words, it has to be logically connected to some relevant fact in the case. It has to make sense. There has to be a connection. The attorney who is presenting it will have to establish that it's material to the issue. And finally, the evidence must have probative value, which means it must have some impact on the jury in their ability to decide whether or not a fact is true. Cumulative evidence. This is something that usually falls under the judge's purview. But when an attorney is bringing in testimony from multiple people that restates and tries to reprove a fact over and over again, it becomes repetitive. The judge might exclude some of that evidence. The example here is if 10 witnesses are going to give basically the same testimony or account of what they saw happen, the judge might say, listen, 2 or 3 of them can testify to this, but we're not going to listen to all 10 people say the same thing. Corroborative evidence. This is evidence that supports some testimony by proving additional facts that would confirm and tend to confirm what the witness testified to. The example here is a witness says that he saw the suspect shoot a gun, and corroborative evidence might be ballistics that show that the gun was fired. It might be a GSR test, which is a gunshot residue test, showing that the individual that the witness testified about actually fired a gun that day. It might be fingerprints that show that John was at the scene or was at that location. So that kind of backs up what the witness said. That's how corroborative evidence works. Direct and circumstantial evidence. So all evidence is divided into two types. Direct evidence establishes a fact exists based on someone's personal knowledge or observations, whereas circumstantial indirectly proves a fact based on inferences. So what are we talking about here? Let's say somebody testifies they saw John entering Phil's apartment. They saw it themselves, and that's their testimony. I saw John go in there. Circumstantial evidence might be that we can infer that John killed Phil because Phil died right around that time. That might be circumstantial. Nobody saw John kill Phil. The witness might say, well, John comes over about this time every day, and John drives a red VW Bug and always is driving that Bug. On the day in question, I saw that VW Bug parked right out front about the time John usually comes over, and I heard somebody go into Phil's apartment. So that's circumstantial. You can draw a conclusion that John must have been in the apartment or might have been in the apartment. That's up to the jury. But that's circumstantial. It's indirect. Doesn't prove it, but it is admissible. Testimonial evidence. These are words. These are words of evidence given by a witness. They have to be given under oath. Somebody is sworn in the courtroom, and then they can say what they saw, heard, or know. That's testimonial. All evidence in a case has to be introduced through the testimony of a witness. That witness might be a police officer who collected the evidence at the scene and properly marked it, packaged it, and booked it into evidence. Or it might be somebody who saw the suspect shoot the victim with a gun. So the way that evidence is introduced, it's through witnesses who must be under oath. They must be sworn in before the testimony that they give. Another way to introduce testimonial evidence is through affidavits and depositions. These are done in a very controlled manner where somebody is sworn in. It might happen in an attorney's office. There's somebody recording the conversation, and that transcript can be introduced in a similar way without the witness being in the courtroom. Okay, the difference between real and documentary. Real evidence is a lot of times referred to as physical evidence. Things like bloody clothing, the gun, the knife, DNA, fingerprints, things that were physical, that were picked up, located, or seized subsequent to a search warrant, booked into evidence, that kind of thing. Those are physical. And a subgroup of that, of real evidence, is documentary evidence, and that is oftentimes letters, contracts, maps, deeds, things that were written, let's say by the suspect, let's say a journal, or even a Facebook post. But a foundation must be laid first before these things can be introduced during a trial. A foundation simply says that this is why I'm introducing this evidence. This is how it's related. It has to be linked to whatever the assertion is. And that evidence must be relevant. And of course, the judge has to deem it as being admissible under all the rules of evidence. Stipulations. When the two attorneys agree that a fact exists, they can stipulate, which means it doesn't have to be argued in court. They can do that before trial and come in with a written document telling the judge that they've both stipulated to this fact, or it can happen during the trial where there might be an argument or a dispute between the two attorneys. They may agree to stipulate that a fact is true. When the attorneys stipulate to a fact, the judge tells the jurors that they must conclude that those facts exist and give them the same weight as if they were proven during the trial. There are many reasons an attorney might stipulate to something. Here's an example. The fact that's being discussed is whether or not John was at the scene of the crime. Rather than argue that John wasn't there, the defense attorney might be aware that there's a photograph of John, and in that photograph, John looks, or even video, let's say even better. In this video, John looks intoxicated, or he looks angry, or he looks really shady. he may say, you know what? I don't want the jury to see that video, so I'm going to stipulate that John was there, which means we agree John was there. You don't have to prove that. And now the prosecutor can't introduce that video because all it does is tend to prove a fact that's already been stipulated to. And you can't spend the court's time proving facts that don't need to be proven. So that's a strategic example of a stipulation. Judicial notice. This is when the judge tells the jury to conclude that a particular fact exists. This is not one that was agreed to by the attorneys. This is when the judge says, we're not going to waste time arguing over whether or not the sun rose at 6:28 a.m. We're not going to argue that whether or not Rockland is in Placer County, things like that. Judicial notice is usually limited to the types of things that are normally public knowledge anyway, scientific facts, federal, local, international laws, things like that. The judge might just tell the jury, listen, you just need to assume that this is true, and let's move forward. Presumptions. A presumption, its definition is that it's a legal inference or assumption that a fact exists based on the known or proven existence of some other facts. Now that's pretty confusing, but let's just talk about that part first. There are basic facts and then there are presumed facts. So let's talk about the difference between the two. The basic facts are the things that the attorney, district attorney or defense attorney, they have to prove to the jury, convince the jury that these basic facts are true. And when they do that, and if they do that, if the jury believes them, then the jury is instructed by the judge that they must then presume something else. Okay, let me give you an example. Let's say a person is missing for 5 years and they haven't been heard from. The law might presume that a missing person, missing for 5 years, hasn't been heard from. The presumption is that they're dead. If we've established that the person has in fact been missing and they have not contacted anybody and nobody's heard from them and there's been no activity, then legally I instruct you, the jury, to presume that the person is dead and let's move forward with the case. That case might be something like settling their estate. This doesn't count in a homicide. It's a whole different situation with a homicide. You have to have evidence of a crime for that. So set that aside. And I'll give you another example. A lot of times, the court will assume if you put a stamp on an envelope, sealed it, and delivered it or handed it off to the postman, the assumption is that it made it to its destination, that it was received. If that's a disputed fact in a case, the judge might say, we have direct testimony that somebody dropped off this letter. And if you believe that basic fact, then you must then assume that the letter got delivered. I'll give you one more that happens to be in the criminal realm. You've heard of the blood alcohol content of 0.08. A lot of people call that legally drunk. In a DUI trial, the judge will usually tell the jury that if the DA can establish the basic fact through chemical testing and the reliability of the lab that the defendant's blood alcohol was in fact 0.08, if that's established, then you must presume that the defendant was too intoxicated to safely operate a vehicle. The prosecution doesn't have to go to that step of saying, okay, now the person's 0.08, that means that they're probably a little bit too intoxicated to drive a car. They don't have to introduce studies and scientific evidence because that's already been established elsewhere. So the presumption is if you're 0.08 or above, you're drunk. Now all I have to do is prove that you were the one driving. That's a presumption. We're going to stop right there with our definitions for Chapter 4. Please take a look at Chapter 4 and read into the detail for each of these. And we'll see you in the discussion boards.